Well, this segment's being sponsored by Coppolino Dodd Krebs Law Firm, and we can't thank them enough. And we always get to get you on here, and sometimes we're blessed to have you both on. But right now, today, I wanted to talk to you about the jury selection and how it works and how it can make or break a case for somebody. Because
let me say this: we don't talk about all this legal stuff, especially when we get to the jury, because we expect people with an LTC to kill somebody or something like that, or that it's expected, or that this is going to happen. What we're doing is trying to educate you on why you want to be responsible with your firearm, and why you want to know how to use it, and why you want to know the situations, and when it's a good time to use it, and when it's a good time to retreat or run, because you don't want to be in these situations unless it is an absolute necessity.
Right. I mean, I want to back him up by saying, you may do something and it may be okay, but you're going to have to possibly go through a whole bunch of hoops before you get off of it. So in other words, the ride isn't free. But if you know all the stuff that Rick and Ross here explain and we talk about, and it's in your head and you've worked it out and you've practiced it, and you go to yourself, I could probably wait one more second. I might not have to do this. It'll avoid a whole bunch of problems.
Right, exactly. You'll be more efficient in your use, and you'll be more responsible in your use. And so that's the whole point of it.
That's a good way to put it.
So, talking about jury perception, I think I'm gonna call James Burks out. He always has a good story that he likes to tell. They had jury trial one time over here, and John Reddington, he's been on the show, was out there, and I think Jimmy Morgan was in the case, and James Burks stood up. They said, "Does anybody know Jimmy Morgan?" And James Burks says, "I know Jimmy. If he's arrested, then he must be guilty." So of course,
that just
James,
a whole bunch of people.
Right. Of course, James was trying to get out of of course, he was trying to get out. I mean, Mr. Burks, excuse me, not James. Excuse me, Mr. Burks was trying to get out of the jury duty, but so that's a lot of the times what these jurors are trying to do, which makes it really hard to know who you're picking and what you're getting, and it makes it really hard to communicate with everybody because they're not wanting to be open with you and honest. And so you can say that you want a certain type of juror, and you can say that these jurors are the best, or you could say that you want to deselect these kinds of jurors, but the bottom line is there's always an element of luck when it goes into picking a jury.
And bad luck.
Bad luck, sometimes good luck. Sometimes good luck, but my point is not everybody's going to cooperate. Not everybody's going to be open, and you don't really have that much time. In some cases, like a DWI case like that one that I was saying, or some kind of, misdemeanor case, you're only going to have about 15, 20 minutes to talk to 60 people.
I was on a jury selection one time, and actually Rick was one of the attorneys talking. They're asking all sorts of questions, and they ask questions in a way, it's almost like you're the one on the stand who is being tried, because they want to make
Rick
sure.
Rick is kind of mean, right?
I didn't say that.
Rick's really aggressive. So Rick has a more modern style. He'll even tell you that. He'll talk to you about it. I wish he had been on the show today. He has a style of jury selection. He has a bunch of thoughts about jury selection that are really, really very interesting, and a little bit different than a lot of people. So I'm sorry, I didn't mean to interrupt you. He's just different. He's a little bit different.
I take you as a Mack truck hitting somebody head on. I take Rick as a guy who comes from behind you and slits your throat with the tactics. He's very knowledgeable, experienced, sly. And I don't mean that in a negative sense. I mean that he knows. We've talked. He said, "I've been doing this. I've had it done to me, and now I know which buttons to push." So he's very able and good to get information that is needed to get out there in ways that somebody might not normally give it up before.
How about calling him tactically adept, strategically adept instead of sly?
Okay, sure.
Yeah.
No.
There's no offense by that.
Oh, that is a lot of it too. I mean, there's a lot of strategy that goes into play. I think some of it is just our personality. Mm-hmm. It's not that I'm not going to be prepared to know exactly what questions I need to ask from a strategical standpoint, right? But this is my personality, and when it comes to trial work, you can't avoid your personality. If you try to be somebody you're not, it's not going to work.
Not going to work in anything.
And
right.
so that's his personality and my personality are nothing. We're not, we get along great. We have a lot in common, but we don't. Our personalities are not even close to the same. We're totally dissimilar. And so I'm sure he's got a different. But I feel like he's a little more rough. I'm a little more straightforward, I think, but I don't say it as callous. Does that make sense?
Yeah, I hear you.
I say he has some pretty direct. I mean, he asks some pretty direct questions, pretty directly.
I think he does that because he knows he's summed up the individual he's talking with. If you know personality, because we talked about this, if you know personalities, and you can figure that out real quick on people just with their body, their mannerisms. If you say certain things, you have a good chance that they're going to respond a certain way, which is going to open up the door to ask other questions in the right direction to get the results that you want.
That's true, but that's why I try to build a little bit of a rapport first. So no, I'm not saying he doesn't. He's a likable attorney. I don't think there's any way that I could ask the questions in such a way. And we're talking, nobody can hear him, so it's kind of
Well, Rick,
pointless.
if you're listening, give us a
It's
call.
it's kind of pointless to sit here and do the comparison unless they can hear it and understand what we're talking about. But I don't think there's any way I could do what he did. I'm not really sure that he could probably do what I do. It just wouldn't work. I
It's
think
just the way it works, man.
right. And so I mean to say, I said a while ago like who you're picking.
No, wait. Let's clarify why we even brought this up, because in the jury process, we're
Right.
going to ask you a bunch of questions. So the reason we talked about the comparison is sometimes, depending on who the attorney is picking the juror, it
Right.
depends on how it's going to.
And that goes into play about who you want on your jury too, because a valid reason not to get somebody on the jury is if there's a personality conflict between the juror and the lawyer. And I have had at least 3 jurors just for some reason they didn't want nothing to do with me. And one was a traffic ticket case, so I understand, ma'am, right? But I'll never forget that one. She was probably the meanest. Okay, but the other ones, yeah, I mean, sometimes they just, oh, you're a scumbag defense lawyer. You're just a scumbag. So, and the media does such a great job of making criminal defense lawyers look just terrible. And then, you do a personal injury case, and the corporations have done such a good job about putting it in the media that all we're out is for the money. And so, in both those cases, it was just like those people. I don't like lawyers, especially ones like you. And you never met me, okay? But so you're those are valid reasons to get rid of somebody. And what's called voir dire. So it's jury selection. But I think a lot of jury experts would tell you that it's not so much jury selection as it is jury deselection. A lot of times what we're trying to do is get rid of people who would be unfair. Now, they always talk about this, it being deselection, but then they'll talk about the exact kind of jurors that they want. So, I mean, sometimes, yeah, you're going to try to fight for somebody. If you think you've got an actual shot to get that person, you're going to try to calculate based on the fact that you want this person. But, yeah, it's really, you want to get rid of people that are going to hurt you. And so that's what the focus is going to be, because you want an impartial jury. But really, a guy I used to work with, tried a bunch of trials with. I had a bunch of trial cases. Clyde W. Chandler, he's passed away now. He used to go in there and say, I'm not looking for an impartial jury. I'm looking for a jury who's going to listen to what I got to say.
Oh.
I want a jury who's going to take my side of the table. Right? And he used to say it all the time. It's honest. And I loved it. I think it came across well. I think people understood what the point is, that the state is going to try to deselect as many people as they want so that they get the people that listen to their side.
That's right.
And so Clyde wanted to get as many people on there as he could to listen to his side, to make it a fair trial.
He's just saying what's totally obvious anyway.
Right.
It's the elephant in the room, and just he's actually saying.
And so I love that aspect, and there is some truth to that. But at the same time, we definitely want to get rid of the anti-gun activist right, in a self-defense case. And I can tell you these things are not always apparent. And so, I mean, I even had a recent case. I obviously can't talk about it. It's confidential information, privileged information. But I'm going around trying to see what the likelihood of winning a trial in this case. I really wanted to try it so bad. I just couldn't even sleep because I wanted to try the case so bad. And I thought it was unfair. The district attorney's office here in Milam County was a little overzealous, I think, in this case. Right, and I really wanted to go after it, and so I mean we have great people in the district attorney's office. I think there was some pressure coming from outside sources, and so it was just a situation. It was a bad factual situation all around, and so. But then I start looking around, I start asking folks, and I'm asking people that I feel like are totally on my side, that have always been very conservative. Physically but socially liberal, Okay, and that this is a great person to start off with, and I got a completely just response that was out of left field, and sided with the state, and so I go, well, maybe the state's not being so overzealous. Okay, and so, I mean, that's when you start to really question, like, man, can I win this case, and what are my jurors? When you don't even know who your jurors are going to be, and then I'd pick a person and I thought, oh, they're going to say I'm going to lose. I'm going to say I'm going to lose, and I'd call them in, say, come look at this video for me, see what you think, and they'd come in and go, is that even a crime? And then you're just like, what is going on here? And so I mean, sometimes my point is sometimes trying to figure out the merits of a case, and that's what I'm saying. I'm sitting here calling the state overzealous, even though I do think it was a little bit overzealous still. But I was sitting here thinking, man, this is way out of line. This is unfair, like totally. And then I'm getting all these mixed emotions from people, and you start to see like how many different views you can have when you talk about people.
I hear this a lot about how when the jury is selected, they are told they can only judge on a couple of different things. The judge will present to them what they have to give an opinion on, or help me with the terminology. But they're given just one or two things, but all of a sudden, when those one or two things aren't even discussed, and they come up with an emotional outcome as compared to, was it yes or no, was it A or B? They come up with something totally off of what the judge has asked. I hear this a lot. Can you emphasize on that?
Well, you're going to have a jury charge at the end, so the judge doesn't ask any question. I mean, he reads the jury charge, but there's going to be, and that's what a good trial lawyer is going to do. They're going to look at the jury charge from the very beginning of the case, and they're going to look at it from a jury trial standpoint. Can I win this case? Right? If you're talking about a criminal defense side, you're going to see, can I win this case? If not, I'm going straight to the DA and trying to get this worked out as soon as possible. Right? If it's a gray area, maybe you got some strategic moves you want to make first, maybe to put some pressure on them, maybe to stall, I don't know, whatever it is you want to do. Those come into play. From a civil standpoint, you're not taking the case, right? Unless there's a chance of success. I mean, Rick will tell you right off the bat, you unless the case is worth something, looking at the jury charge right at the get-go, right, then you're not going to invest a bunch of money like he would do. Does that make sense?
That makes sense to me, yeah.
Okay, so, I mean, those are the questions that the jury has to answer your question. And do they answer that question based on things that are not evidence, that didn't come in? Yes. So research shows that at least 50% of the juries decide the case based on their own personal experiences, and that's what they discuss within the deliberations. They don't discuss the case.
So it's almost as though the case was worthless because they've got the bullet points in their head, and based on what you just said,
It's like that. It's like bullet points. It's like, so, well, the person approached me. Well, I remember my husband did this one time, and then this is how we handled that. I just think this was wrong. And then so he said, yeah, we had the same situation, and so they might not even consider the evidence. I mean, that's how about research shows anyway. We don't know what goes on, though, to be honest. And
don't they talk about it after the case? Sometimes you hear it.
Sometimes they do, yeah. Sometimes
Are you allowed
they
to do that?
Yeah. I do that every case. I try to go up to people and say, what did I do wrong? Tell me how to get better. What can I do? So it's been helpful in some cases, and some people are just ugly and they don't talk to you at all. And it's just like, I mean, some of them are like they'll go talk to the. Not if you don't want to talk to anybody, it's fine.
I can imagine.
But they'll go talk to the other lawyer, and they'll just look at you like, you scumbag. Why do you not like me? I'm just doing my job. Like, why do you? I mean,
don't they worry about repercussions coming back to them if they said that they voted to put somebody in incarceration for life? Don't they worry about? They want to stay kind of hidden as to what my thoughts were and how I voted for it, so I don't have these family members coming and get me.
There's some people like that, but you'd be surprised. I mean, jurors love talking. I mean, especially in a not guilty case. I feel like when it's a not guilty case, boy, they love talking about it.
They feel like they help liberate.
Or I think they just feel like this wasn't a good case, and they love talking to the prosecutors too. They say, "Look, you guys did a great job. This is what the one thing was," and then the prosecutors go, "Oh, hey, but you didn't know he also had 10 other felony convictions that we couldn't bring in." And then
why can't they do that?
And then the jurors will go, "Oh man."
See, that's what I don't get. Why can't you bring in all the information? Why it's some, and who decides, and how is it?
Because they would decide it on those 10 felony convictions as opposed to what the actual evidence was in the case. right? And it's very valid in some situations. I mean, it's been a very good rule in some situations. And look,
So
man,
if somebody-
judges let in stuff, a lot of stuff. So,
Oh.
I mean, they let in a lot of stuff. I would say a lot of times, most of the harmful stuff, it comes in. It's really that irrelevant. So there've been a couple situations though where, really, really harmful stuff. It was like just prejudicial.
Okay, so here you've got a person
that
going to
wouldn't come
court, and now you got to worry about the jury. Now you got to worry about the judge's opinion and what he's.
Oh,
gonna
exactly.
allow in.
Oh, yeah. The judge can control the outcome of the trial. for
Okay,
sure.
so we're here talking on the radio right now because I wanted people to understand when you're out there, whether you got a license to carry or not, and something happens, and let's just talk the self-defense realm. And for some reason,
Self-defense is. I wanted to talk about this. So self-defense is kind of a rare, a strange beast, right? So a lot of times you don't want people that are real security oriented, right, on your jury, and you don't want crime victims on your jury. Think about it. If it's a robbery case, you don't want a robbery victim on your jury.
no, of course not. No.
Okay, I mean, but it's the same concept. You don't usually want crime victims. Like that's what was the first question I asked. In a self-defense case, I might even be okay with having law enforcement on the jury.
I guess it depends on the merits of the case.
It does. It does. Every case is different. Goes to the facts. But in a self-defense case, you have this switch. The case, the roles switch because the defendant is not really a defendant, right? The defendant is saying he's a victim.
Mm-hmm.
And he's saying the victim is the defendant because the victim would be a defendant but for his death. Okay? Or but for the actual victim got the better of him. When I say actual victim, I mean the defendant in that's being tried. Right? And he's throwing up the self-defense claim. Okay? And so you get a crime victim to come in and say, "Yeah, had I been trained and I knew how to use my firearm, I would have used it on that SOB who attacked us, 5 years ago."
Mm-hmm.
Right? And so they understand and they can see it they can really feel it from, right, this person's shoes, this defendant's shoes. Okay? And so, I mean, a lot of times those are the people you want when you would never want those people on a jury, and you would never even consider law enforcement, right? But it may be. Because law enforcement would use a weapon if somebody threatened them.
Sure.
And so law enforcement's going to understand that too. And I think anybody that security is concerned with security is going to understand. What you don't want is, like I said, somebody that's got a hidden agenda. Like they're an anti-gun activist. They want to, and they're not going to want to reveal that to you. They're not going to want to reveal that to you when you talk to them in jury selection or deselection, however you look at it. And so they're going to get on this jury, and they're going to act like they're silent and a follower, and you think they're not a big deal. And then they're going to get in there and they're going to try to sway everybody. Right? And those are the people that really concern me because you can't get this out and they do have this hidden agenda. Another one that I worry about, and they don't always do it intentionally, is what's called the motive juror. Richard Gabriel has done like the O.J. Simpson, did the girl down in Florida, the big case down there. Casey Anthony case, did another major case. He's a jury selection expert. Right, he comes up with all these names and stuff, but he's got. So you got like a motive juror, and what they'll do is they'll listen to the state story or the first story that they hear, okay, and sort of get involved in that narrative, and then seek to prove that out through the rest of the case. That makes sense. They'll get hooked in that narrative, and they'll think that's it, and they'll try to justify that narrative all the way through the case.
Right.
Okay, and then there's another one. You have the presumption of guilt juror, who's always a problem for a criminal defense lawyer because they're going to think.
How can you say presumption of guilt? How can you do that? It's either you're guilty or you're not guilty.
The rule is you're not guilty until proven.
Doesn't seem that way in many cases. But
Okay, unless proven. Excuse me. Okay, unless. All right, and so this way the people though have an opposite presumption. They presume that you're guilty because they say, well, they wouldn't be trying the case if he was innocent.
Right.
Right? And so that's always a problem. And so you're always going to have these people coming in and prejudging. And people say that, I mean, most people, I feel like a lot of folks are honest about that. They come in and, when we ask them, how many feel like since he's sitting here today that he probably did something he's guilty of? I mean, I mean, you get half the hands in the room.
Man, we're all guilty of something, aren't we?
Right, and so I mean that's true, but I mean they all raise up. And how many of you guys think he did this crime already? Like you've already made your mind up. I mean they'll raise your hand, and that's not a good question. We still have to go into it, and so that's not enough to get those people struck out for cause that they'll say we can still follow the law, but it shows they come in with a leaning or bias, and it's a lot of folks a lot of time.
A few shows ago, probably more than that, you were on here and you made a comment about, when time comes, don't think about anything, just do it. Okay? And you're right. I didn't like the terminology. We cleaned it up a little bit, but it's right. So what I'm bringing that up for is this reason.
What is the terminology? I'd rather be judged by 12 than carried by 6.
Yeah. But what I was getting at was, you want to study your law, you want to do your training, you want to do everything you possibly can to prepare yourself, mentally, physically, the whole works. And you've got to, you being everybody listening and us, you've got to have that line in the sand. There's got to be a line in the sand where you go, I don't care the rationality of it, I don't care the legal part of it, I don't care anything. I know a man's got to know his limitations, as Clint would say, right? I know at a certain point it's beyond what I can do, and my last defense is, I don't know, pulling your gun out, taking a shot, doing whatever you got to do. Your head's going under the bow of the boat. Because if you do something before that line, and because you weren't trained enough or mentally prepared enough, and you do something, then you come into play, and you, well, let me finish my thought, and you got to deal with everything we just talked about. The judge, getting a good attorney, getting a good jury, what kind of charges are going to be brought up against you because you didn't wait to that line because of lack of preparedness.
That's a good point. So I mean, and that's why I said that's where the issue is going to come in. You're going to have different people have different views about what's reasonable, about what was immediate, about what was a reasonable use, and that's why the presumption, right, that it was immediate and reasonable. Okay, if they're coming in your house or about to come in, attempting to, or coming in a vehicle or in your office. Okay, that's why those presumptions are so important, because you can't be charged. Okay, you're not going to be in the situation. It's when you're out on the street and you're not in your home, or you're not in a place where the law protects you absolutely to use this kind of force. Then that's where the line's going to be, or it's going to be drawn in a different spot depending on which person you ask.
Well, that's right. Depending on who you are, your line will be different.
Exactly.
That's why I say I can't tell you the line. I can't tell you when to do this. I can only tell you best methods of deploying a weapon, or how to accurately shoot the weapon, or what the law says, but I cannot tell you when to shoot that gun. So you may have some petite young lady whose line in the sand is 2 feet away from her, and then you got this big hulk of a guy and his line's 10 feet away.
Oh yeah, we've talked about that. Yeah.
So it's all perception.
Exactly.
Perception of threat, pot.
I think I at least wanted to get out there before I go. Defense lawyers do not try to stack. This is a bad myth, and it's actually sometimes opposite. Do not try to stack juries with stupid, gullible people. In fact, especially I always say, the state always says we try to do this in forensic cases. No, every forensic case I've had, I've wanted intelligent people, because when I cross-examine these experts, right, and I show that they're stupid, right, I want the jury to see that. And if they're not smart enough to pick up on my questioning, they're not going to understand the points that I'm making. And so to say I want stupid, gullible people is absolutely incorrect. Now, I mean, I'm sure that's true in some cases, but that's true for both sides. Both sides need gullible juries sometimes.
Do you find experts at times get the spotlight and they want to just...
oh, they definitely get spotlight. There's been all kinds of studies showing that the juries just believe whatever they say.
Because they got the key expert, or they wrote a book or something, right?
Right, and there's junk science. I mean, there's junk science out there everywhere.
How do you clarify that? How would you know it's junk science as compared to not being junk
right
science?
Now, the standards are super weak, but I mean, basically anything's coming in now. It used to be very strong. You used to have to get this down, except maybe Rick's always talking about in a lot of his med malpractice cases. Obviously, the legislature, there's a lot of hurdles to go over, and the judges aren't very friendly in those kinds of cases. Especially you're talking about professionals you're suing sometimes, so people don't like those. So the standards in those kinds of cases are very difficult, right, for people, personal injury attorneys to get, because the system's unfavorable to them.
Mm-hmm.
any other time, these standards really are easy to get. If the other person really wants it in and is, got enough evidence, it's going to come in. And so the way you do it is through great cross-examination.
I got a question, it's a little side question here. How does some people constantly get jury selection and others almost never get it?
I don't know. Yeah, that's a good question.
It is. I'm serious. A lot of people get it. I'm getting a time sign. Okay, thanks, Trey. Recap it. Give me a recap, 30-second recap, and then tell us who you are and where you're at and how they can get a hold of you.
Just be responsible in your weapon use, because jury selection is based on luck, and it is going to take a good lawyer to be proficient at picking a jury. So you're going to have to pay a lot of money in the end anyway, and you're going to have a lot of worry about whether or not you're being judged fairly.
Do you feel the attitude towards guns is different? Because look at all the states now letting concealed carry, open carry.
That's what I told you. I just talked to this guy. I mean, it's a guy I thought 100% is going to be on my side. And I'm talking to him. I show him the tape. All of a sudden, I felt bad because I was judging the district attorney's office here. Right? And so, I mean, hey, it is what it is.
It is what it is. Okay. All right. Tell everybody how they get a hold of you.
Hey, thank you guys. And Rick, too, we appreciate it. I wish you was here today. You gave some good insight. But Benton Ross Watson here in Milam County, 105 East Main Street. You can email me at benton@watson.legal, benton@watson.legal, or call the office at 254-605-4140. That's 254-605-4140.
As always,
Thank you,
Ross,
man.
It's a pleasure.
All right.
Thanks, Rick.